Model answers tailored for UPSC Mains GS Paper IV, Ethics, Integrity, and Aptitude, under the topic Information Transparency and Right to Information, RTI. Question 1. Transparency as an ethical imperative. Q1. Transparency in administration is not merely a legal obligation under the RTI Act, but an ethical requirement for good governance. Elucidate with examples. 150 words, 10 marks. Answer structure. Introduction. Transparency is the practice of open, accountable, and accessible decision-making in public administration. While the Right to Information, RTI, Act, 2005 provides the legal framework, transparency fundamentally roots itself in the ethical imperative of public trust, stewardship, and democratic accountability. Why transparency is an ethical requirement? Subverting the culture of secrecy. Legacy colonial governance relied on the doctrine of opacitous secrecy via laws like the Official Secrets Act, 1923. Ethical governance demands shifting the burden of proof onto the state to justify keeping information secret rather than disclosing it. Upholding public trust. Public servants act as trustees of national resources. Withholding information creates asymmetric power dynamics, breeding corruption and eroding public confidence in state institutions. Enabling meaningful participation. Ethics in governance requires citizen empowerment. Without accurate information regarding welfare distribution, budget allocations, or policy rationales, democratic participation remains superficial. Deterrence against arbitrariness. Sunlight is said to be the best disinfectant. Open access to files, social audits, and proactive disclosures deter favoritism, nepotism, and discretionary misuse of authority. Illustrative example. The Mazdoor Kizan Shakti Sangathan (MKSS) movement in Rajasthan demonstrated that access to muster rolls and local expenditure files directly stopped the siphoning of public money in employment guarantee schemes. Transparency transformed passive beneficiaries into active ethical guardians of public funds. Conclusion. While law enforces compliance through penalties, ethics ensures compliance in spirit. Promoting proactive disclosure, Section 4 of RTI Act, shifts civil servants from reluctant disclosers to ethical stewards of information. Question 2. Ethical dilemmas and conflicting rights. Q2. Examine the ethical conflict between the right to information and the right to privacy in public administration. How should a civil servant reconcile these competing values when deciding disclosures? 250 words, 15 marks. Answer structure. Introduction. Public administration frequently presents situations where two desirable virtues collide. The conflict between transparency, right to information, and confidentiality, dignity, right to privacy, represents a classic administrative dilemma under GS Paper IV. Core areas of conflict. Public servant assets versus personal privacy. Disclosing the personal assets and liabilities of public officials or candidate profiles ensures integrity, but raises concerns over safety, family harassment, and unwarranted intrusion. Whistleblower identity versus natural justice. Revealing an informant's details might uphold transparency of procedure, but exposes the individual to severe bodily harm or death. Medical records and personal details of beneficiaries. Publishing list of beneficiaries under welfare programs, e.g., HIV treatment, mental health funds, promotes auditability, but risks stigmatizing vulnerable citizens. Framework to reconcile the dilemma. When evaluating RTI applications involving personal data, a civil servant should apply the following ethical test. The larger public interest test. Under Section 8(1)(j) of the RTI Act, personal information can be disclosed if the larger public interest outweighs the harm to the individual's privacy. Doctrine of proportionality, Paperaneswar judgment, legitimacy. Does the disclosure serve a valid legal and public objective? Necessity. Is disclosure the only available mechanism to achieve transparency? Proportionality. Is the extent of disclosure strictly minimized to avert undue harm to personal privacy? Severability, Section 10. Redact or withhold sensitive personal identifiers, names, addresses, biometric data, while releasing the core systemic data or decision-making reasoning. Conclusion. Transparency should not become a tool for voyeurism, nor should privacy become a shield for official wrongdoing. A public officer must balance both using constitutional morality, objectivity, and empathy. Question 3. Institutional integrity and implementation challenges. Q3. Despite being a revolutionary tool for citizen empowerment, the RTI Act faces severe operational and ethical challenges today. What measures are needed to restore its effectiveness as a tool of integrity? 150 words, 10 marks. Answer structure. Introduction. The Right to Information Act, 2005 revolutionized Indian democracy by empowering ordinary citizens to question authority. However, procedural delays, structural backlogs, and hostility toward applicants threaten its core ethical intent. Key ethical and operational challenges. Pendency and vacancies. Chronically vacant positions in information commissions create massive backlogs, turning justice delayed into information denied. Frivolous versus genuine applications. Misuse of RTI by blackmailers or for personal vendettas burdens public authorities, giving bureaucrats a pretext to treat genuine applicants with suspicion. Attacks on whistleblowers and activists. The lack of robust protection mechanisms exposes RTI activists to violence, undermining public courage and moral action. Weak proactive disclosure. Section 4. Public authorities fail to voluntarily publish routine information online, forcing citizens to file applications for basic administrative facts. Corrective measures needed. Automated proactive disclosure. Mandate comprehensive digitized records with open data formats so that citizens rarely need to file manual applications for public records. Protection of informants. Stringent enforcement of the Whistleblowers Protection Act alongside localized legal assistance for targeted activists. Fixed timelines for appointments. Ensure information commissioners are appointed well before vacancies arise, maintaining independence from executive interference. Public service ethics training. Sensitize public information officers, PIOs, to view RTI requests not as adversarial threats, but as feedback tools for administrative improvement. To deepen your preparation for GS Paper IV on this topic, solve an RTI ethics case study with a practical decision matrix. Get key Supreme Court rulings on RTI and public interest.